What is that? What did you promise me you were not going to do? Guess what happens now, Mr. Gonzalez? Guess what happens now? Did you say nothing?
I'm not sure.
Not only am I putting you in jail now, but I'm going to make your bonds.
Now, before we get to that explosive moment, you need to see how this defendant ended up back in front of the same judge after making a promise he clearly wasn't supposed to break.
You picked up a new case. You picked up a new case.
So,
Tell me there was a no driving affidavit in place. He's charged with failure to stop and give information, and now he's picked up a racing case. Tell me that we had ordered him not to drive.
Yes, Judge, on the previous case, there wasn't a driving affidavit.
You promised me that you weren't going to drive. Mr. Gonzalez, now you've picked up a racing on a highway. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers observed two vehicles accelerating at a high rate of speed from 70 miles per hour to 85 miles per hour in an attempt to outgain each other. The officer initiated a traffic stop on the defendant's vehicle. When the officer told the defendant that he was being stopped for racing, the defendant responded, "Yes, sir." And the defendant told the officer that he did not have a valid license or registration.
Is there a co-defendant?
There is not any co-defendants charged.
All right, guys, buckle up because this courtroom hearing escalates almost instantly. What starts as routine traffic and probation cases quickly turns into a judge confronting defendants over broken promises, repeat violations, and dangerous decisions. One teenager gets caught racing after personally swearing he wouldn't drive again, while another defendant nearly loses everything over a years-old warrant. By the end of this hearing, the courtroom shifts from giving second chances to protecting public safety at all costs.
Vic, can I see that, please? I'm printing something out. What is that? What did you promise me you were not going to do? Guess what happens now, Mr. Gonzalez? Guess what happens now? Did you say nothing?
I'm not sure.
Not only am I putting you in jail now, but I'm going to make your bonds high. And now you are looking at a contempt charge of 180 days in jail. And we are going to have a hearing as to whether I'm going to hold you in contempt. So now I'm going to file a third case on you. And you are now looking, if they prove to me that you were driving in this case, you're looking at 180 days in jail, flat, day for day. Do you understand?
So,
Goes with you. I'm sorry, Sonia, but I'm setting the bonds at each at 10,000 and 2 each. Two, 5, 3, 9, 9, 8, 0. He will auto-populate on tomorrow's docket, and then we'll just go through the rigmarole. Or, I don't know.
He's gonna be able to pay that. He's a high school senior.
It's a damn shame.
I don't know what his parents' financial situation is. I'll talk to him and find out.
Talk to the parents, and then, I mean, I don't know what to tell you. You know, I need to make sure he understands it and that he gets it. But you swore to me you weren't going to drive, and now you're racing. Unacceptable. You know. I'm going to make it higher. He was wearing an Armani shirt. He was probably wearing a $200 to $300 shirt right now. 15,002 on both.
Okay, Your Honor.
And then we'll see tomorrow. He'll populate tomorrow. We'll talk again tomorrow. Reach out to the family and you know, perhaps they'll come here and they can see how he is and he can see that we mean business now, you know? Okay, thank you so much, Sonia.
Judge, you were looking the new.
You were Destiny Collins.
This is where the judge completely loses patience with Mr. Gonzalez. He had already promised the court he would not drive, but now he's accused of racing on the highway without a valid license. That immediately turns this from a traffic issue into a trust issue. You can hear the frustration in the judge's voice as the bond amount keeps rising and contempt charges suddenly enter the conversation.
We issued a warrant for your arrest because you failed to appear for court, ma'am.
The paperwork, I told him the same paperwork, it said I was supposed to appear today. If that's the case, my bail bond company should have told me the same thing, but my court date was for today.
You were ordered to appear 11/22 of 24.
I got out of jail that day. I was released from jail on Wednesday of this week, last week that just passed. So it was no way possible. I could have made it to court that same day. I got released from jail again. And I didn't get released from jail till Wednesday at like 1 o'clock in the afternoon. And then also I have the picture. I didn't bring the physical copy because I forgot it, but the paperwork that they gave me when I was leaving, that said my conditions. I have a picture on my phone with my name on it. It says today at 8:30 in the morning. So I showed up today. If that was the case, I would have showed up when I was supposed to come to court. So I don't get that. And I just sat in jail for a week and a half. I cannot go back.
You issued the warrant on the 22nd, right? This is Miss Collins. She's not on docket today.
What's the case number?
252-6615.
Can I show you the same picture?
She was on the docket on the 20th. She was supposed to be here on the 20th, correct?
The bond paperwork shows.
I'm confused. I'm confused.
It's not open.
Can I grab my phone and show you my
Don't
picture?
talk to the prosecutor, please. You're not allowed to. I'm trying to figure out what's going on, because if there's a problem and it's not your fault, I will reinstate your bond.
Judge, so on 11/20, she failed to appear. Defendant not present in holdover is what Jamae wrote on the reset. So she wasn't brought up on the 20th. So she rolled it to the 21st, and then the surety bond was posted. The surety bond says 11/20. So it seems to contradict itself. The 20th.
So whoever wrote the bond did a mistake because they put
Whoever hand wrote 11/20.
back in time as opposed to, so what, you said you have paperwork that says that you're supposed to be here today?
I left the physical paperwork at home, but I had my brother send me a picture because I forgot it. I can
Okay.
show it.
Yeah, sure. And you can give it to Deputy and she'll. You see that it shows today's date?
I like it.
Yes, Judge. November 26th at 8:30
Okay,
a.m.
all right. Yep, you're right. Okay, I'll reinstate your bond. Okay. So it looks like while you were in custody, they appointed you a lawyer. I don't know that Martin even knows. I mean, there's no way he's gonna know.
Especially if she's not on docket today.
Right.
Maybe no.
Oh, I have his number. I'll call him. Let me see. I have a Miss Destiny Collins that's on docket today. Are you in the building? So you were appointed, it looks like, while she was in custody. I don't need, say it again? She was in custody in Fort Bend. Huh. Okay. Do you want to stay on the case or do you want me to appoint someone else? Hey, okay, no problem. You just tell me. So that's it? Done. We'll do it. Okay.
This moment takes a surprising turn because the court realizes Destiny Collins may actually be telling the truth. She insists her paperwork listed the wrong court date, and once the judge sees the photo evidence, the entire tone changes. Instead of treating her like someone making excuses, the court starts investigating whether the system itself caused the problem. It's a reminder that one paperwork mistake can put someone right back behind bars.
Do you understand? Okay. Do you mind giving an application, please? All right. I'm going to have you fill out the application and then we'll do not leave until you sign all our bond conditions, ma'am. Okay. Good morning, Miss Lewis. Ma'am, you were wanted out of Missouri for receiving stolen property. Tell me, Ms. Oko, what did you guys want to do?
Well, she would like a bond out on this case. I believe this was in 2022, this was picked up. And according to.
So you said that the case originates from 2022?
Yes, Judge. However, she did, it arose out of a traffic ticket. They got pulled over, car was searched and things like that. And so she kept in touch with the courts to see what she could do. And they kept telling her that she had to pay some money. She paid some money and that was it. She didn't know that there was a warrant out for her arrest. She didn't know there was court. She didn't know any of that after that math. And plus she's based in Houston. So I would assume correspondence should have been sent her way. She didn't know until she got picked up as of yesterday. She does live here. She's got her parents here. She's got support. So they're willing to help bail her out and make her go to Missouri so that way she can in person handle it.
I'd be opposed, although the probable cause for the stop was a traffic citation or infraction, is that the receiving stolen property is coupled with an unlawful possession of a firearm and it's a failure to appear. It's not a 2B. So she went in front of a judge, stated that she would return, and then she did not return.
And now it's 2 years later.
The warrant was issued out on December 8th, 2022.
You've been gone for 2 years. And how do we get her now?
I don't have the offense report. She wasn't charged with anything else here, so my best guess is
Somehow she got just picked up.
right. And so, I mean, I can source the OR, but I don't have it on my person.
It was a random stop, Judge, a traffic stop, I think, broken
No,
tires.
I am always amenable. I shouldn't say always, but I'm very amenable to giving people bonds when, number one, they're not a danger to my public. And number two, I have faith that they're going to go back. Your case is now 2 years old. You've been in flight for 2 years. You've made no attempts to do anything. And the only reason we have you now is because you got arrested. Had you not gotten arrested here, you'd still be in the wind and they would still be looking for you. So I don't have faith that if we give you a bond that you're actually going to go. I know that you're going to tell me it's little gumdrops and rainbows and bunnies jumping in the woods, but at the end of the day, a flight risk is a flight risk. And who you really are is on paper, because everybody tells me and promises me sun, moon, stars, this, that, to force you to go back. And I just can't take your word for it.
Well, Your Honor, she does work. And of course, getting a bond would, the incentive of receiving that bond back is one of the things that I've gotten some of my clients to do, to get there. As soon as they go and take care of their case, they're calling me, asking me, how do I get my money back? It's more of an incentive for them. So at this time, like I said, she does have a base here. They're willing to help her out. They didn't know about this whole issue and she thought she had taken care of it over the phone. Unfortunately, that's just not how it works, but she understands that now. And she's willing to go back to Missouri as early as next week to take care of this.
But I don't have faith you're going to go, Day?
For what it's worth, if it wasn't a failure to appear, I actually would have agreed to a bond, but the fact that she went in front of a judge and the incentive originally from Missouri was the bond. And so that should have been the original
when you first came out, I was thinking to myself, it's not the worst in the world. It's not, and you haven't.
I didn't go in front of a judge. I had called them and they said I didn't have to. They said all I have to do was pay it. That's why I just paid it.
Post bond. right?
On this
Yeah,
case.
yeah, I paid everything that they told me I need to pay. I've never been in trouble ever a day in my life. I've been homeschooled my entire life, and this has just come up. So I just called them and I did everything that I had to do. I'll do anything I have to do to get out of this. I just want my life back. I have a business. I have a family. Like, I just want to get back to my family. That's it.
Any other prior criminal history?
No, Your Honor. I mean, if the court wants to roll it over a day, if just wants to call Missouri and talk to the prosecutors up there, or if she has a defense attorney up there. I mean, if it's an FTA, then presumably she would have had an attorney after the first setting before it was forfeited. So if you want to roll it over and talk to Missouri, I'm not against it, but I'm still opposed because it's FTA. Jurisdiction doesn't impose a bond, then generally I don't. So I had that happen last week. Now, what day is today?
Yeah, no, it was last week with us.
Last
Yeah.
week. And so there was one I opposed, but the demand jurisdiction, the prosecutors there said, I'm not opposed to them getting bond, even though I opposed it, they didn't. So ultimately I folded and I said, okay, I'm fine with the bond. So if Chisholm's able to speak with the prosecutors up there and they're not against it, then I'll
Did
defer.
you say you can't be here tomorrow? Is that what you said?
Not that I can't, it'll be the timing, right? If we can, I'm gonna make some calls right now, see if I can make some calls now and see who I can
For
call.
sure,
Yeah,
yeah.
because I wouldn't want to
There's
roll it
no,
over
I mean,
to
we're here for
tomorrow.
at least another hour, so there's
Yes.
no,
I'll make some calls now.
see, if they're unopposed, then I'll set a bond.
Because, and I was, it's because the teletype that we received is, she is eligible for a 2,500 bond there, but they clearly stated that she's not eligible from their jurisdiction for a bond out of state. So they won't allow her to have a bond until she's returned. That's why I said, if the prosecutors are fine with it, they can send me an email, fine. But I'll sit in the pews.
Sounds good. I'll make some calls, Judge.
What you can do. Is there a second case though, too, or no?
No, so the way they did it was, the charge was for both out of the same incident, but for reasons passing understanding, whomever the arresting officer was, they only put one charge. So I had to run the NCIC off of her FBI number to get the second charge. I didn't know until I ran.
Okay. Is this the only fugitive case we have today?
This is the only remaining one. Everyone else
Got
is
it.
in wait, which we're all for the rest.
This hearing becomes tense because the judge focuses on one thing above everything else, whether this defendant can actually be trusted to return. The defense argues she thought paying money resolved the case, but prosecutors keep pointing out she disappeared for nearly 2 years. That's why the judge keeps saying, who you really are is on paper. At this point, the court isn't listening to promises anymore. It's looking at patterns.
How's jail?
Sucks, man.
Great. That's great. Because I got you, I need you to understand that we mean business here. We don't play. And your lawyer I'm bringing you out because it's your case. You need to understand what's going on, number one. Number two, your lawyer has asked for me to reduce your bond. Your bond now is set at $10,000. I have no idea what happened on your case. The only thing I do know is that September of 23, unlawful possession of a firearm by a felon. December 1st, 23, unlawful possession of a firearm by a felon. 5/29/24, unlawful possession of a firearm by a felon. 11/23/24, unlawful possession of a firearm by a felon and a terroristic threat of a family or household member. You now, with us, are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched in response to a family disturbance in Harris County, Texas. The complainant told the officers that her and the defendant, her ex-boyfriend, were having issues regarding child custody, and the defendant was attempting to drop the child off with the complainant, and the complainant refused to take custody because of a previous mutual custody agreement. The complainant told the officers that the defendant then stated, "I just bust your car window, and if you pull up doing anything, I'm gonna shoot your ass in the face." The complainant stated that she was in fear for her life, and the officers detained the defendant and found him to be in possession of a handgun.
All right. Mr. Jack, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you as a condition of your bond not to have any contact with the complaining. What that means is that if you violate this protective order, the state can and will file additional charges against you, violation of a protective order. And I'm going to tell you now, you pick up one of those cases and you violate conditions, I can have a hearing to hold you at no bond, zero bond. And I will do it in a heartbeat to protect my county and everyone in it. Do you understand?
Yes, sir.
I find that you are a complete danger to public safety and you refuse to abide by bond conditions. So I don't think that your bond is sufficient. I think that the 10,000 is too low because you are a danger to my public. I'm sorry, Mr. Elick, but, and regardless, what we do here is just, it's, I guess, peanuts, so to speak, because you're being held at no bond on 2 of your felony cases as is. So, what I am going to have you do, though, is this. I'm going to have you sign with me today an affidavit promising me that you're not going to have any weapons. And if I find that you have a weapon, if somehow you are magically released, because I don't know what's going to happen, if I find that you have a weapon, I will have a contempt hearing. I can have a contempt hearing, and I can and may hold you up to contempt every single time you have a weapon. And if they prove it to me, I can send you to 180 days in jail every single time. Do you understand? This is an affidavit. This affidavit, you're going to promise me that you're not going to have any weapons. I don't care what's going on in your life. I don't care if you're going into war. I don't care if there's a big battle in the street. No weapons. Do you understand? We will have you swear to us that you're not going to have any weapons. And at that time, we'll just have you put back. If you do bond out, I'm going to put a GPS monitor on you, and I will put an exclusion zone so that you're not to go anywhere near the complaining witness in this case. Do you understand?
Yes, sir.
You know, did we ever explore that order to surrender weapons to the sheriff's office? Did we ever do anything with that?
I explored it and I talked to multiple people and no one's ever heard anything about it that I could find.
We had that, remember?
I know at one point we did.
We need to do something with that.
I'll make a few phone calls. See where.
I'm going to see what I can do about having weapons, the weapons surrendered to law enforcement so that you don't have possession of any weapons. Do you understand? Okay. All right, Mr. Lick. So I guess we'll just wait. It looks like the felony case is set for, oh my goodness, March of next year.
Your Honor, we may be, I just want to get the body cam and we may set this for trial. I mean, I know he's got the other felonies, but
I'm itching for a trial. You want 30 days, I guess?
that sounds good.
Yeah. Okay. All right. We'll have you swear to us no weapons. Mr. Jack, come on.
This may be the most serious part of the entire hearing. By now, the judge is looking at multiple firearm-related cases connected to the same defendant, plus threats involving a family member. Courtroom shifts fully into public safety mode, and you can hear it every time the judge repeats phrases like, "danger to my public." Once someone keeps violating conditions over and over, the court starts treating every new arrest as proof the warnings are no longer working.
Judge, I also have Shaquita Mitchell on your docket. We were reset today for the state to eval, which they have done. And I have a pretrial contract that was printed today. We just need some time to get community service done.
She has to do this community service?
Service in 2 classes, and I think she's already done 1 class. And
Great.
we're waiting on another one.
Is she here now?
She is here, Judge.
Ms. Mitchell, come up.
Hours of community service.
What are the classes?
Anger management, Judge.
And anger management, okay. Have you done any of the classes now?
I'm back in Beaumont since this case has occurred. My probation sent me back. So they're gonna have me doing thinking of a change and completing my community service and doing MHMR. So that's the only things I have to do in my probation.
This case, or are you on probation?
I'm on probation.
She's on probation in Jefferson County, Judge, but in addition to that, this case, she's already done an anger management class that she's brought to my office last week. But now the state's offering, in addition to that, effective decision-making 20 hours for it to get dismissed. So I'm not sure if the community service she does while on probation can be used in conjunction with this, but I'm sure we can work something out.
I'm okay with that. I
Okay.
mean, have you done the community service yet?
Yes, I have done some of my community service.
Okay, then I guess make sure that Michael is okay.
Sure.
I am, but you got to understand if you're on, is it felony or misdemeanor probation?
It's a felony probation.
I mean, self-control. I would say 90% of the people that are in jail now are for one reason only, self-control. They react, they act without thinking and say, if I do this, what's going to happen? If I say this, what's going to happen? And then you end up back in jail, you pick up a new case now, and you're on felony probation. Jefferson County is a really tough county. They don't toy around like here in Harris County. You violate over there, to revoke that probation, resulting in further confinement.
I'm not pleading guilty. I gave her all the evidence.
That's right, we're not doing a plea.
Correct, Judge,
Yeah.
we're not,
So,
not entering a guilty.
but at some point, you got to understand, they're not going to continue to bend over backwards to help you.
That's why.
Right?
Because that was the problem.
Well, self-control. It takes two to tango, right? You get into a pissing match with other people, you get into a fight. Don't matter. Everyone's going down. Just think about that. Self-control. All right. So how long is it going to take you to get all this stuff done?
Right now, they got me looking for a job out there. I have an interview today. So hopefully after Thanksgiving, because everything's going to be shut down probably tomorrow.
Well, I don't want to, set you up to fail. I mean, your case is old, but we need to give you enough time that you can get it done.
Can we do the first or second week of January?
Yeah.
That's a long time.
It is, but I know that with Christmas falling right behind Thanksgiving, if she gets it done before, then I can
My
always.
fear is that we get to Christmas, oh, this, that, then nothing gets done. We're here in January and then nothing's gotten done. I will give it to you, but I'm going to tell you now, if you don't have it done, I will carry you day for day until you have it done. I'm literally will reset you Monday to Tuesday to Wednesday to Thursday to Friday, and then to next Monday until you have it done. Your case is 212 days now. We're giving you another 40 days now. You got to have it done. And if you don't, I'm telling you, I'm going to roll you day for day until you have it done. You understand?
And
It's
she's
not hard.
proactive.
Everything can be done online.
She's pretty proactive. She's come to my office often and brought me evidence and proof of her classes. So she's doing everything she needs to. And
It's a
this is
sweetheart deal.
PTI.
It's a sweetheart deal. Work it. All right. Self-control. All right. Good morning, Mr. Houlihan. So you understand that you're entering into a very serious probation. We take it seriously. And if you continue to, if you violate at this point, I mean, we can put you in a rehab facility, right? So just no alcohol from any source. That's all we're asking you to do. Stay out of trouble. If you don't have a license, don't drive. These probations are typically pretty easy. All you have to typically do is 2 classes, stay out of trouble, and don't drink. And as long as you can do that, then you're walking out of here,
Yes, sir.
What are the conditions that we have, Shatoria?
Thinking for a change,
Okay,
CWI education, 2 victim impact panels, TRAS, random urine analysis, no refusals.
what that means is that if you are pulled over and an officer asks you to submit a breath sample, you have to do it. If you don't, then you're in violation of this probation.
No drugs or alcohol. And the guardian interlock.
Do you have you've got the scram now?
Yes, sir.
So what we'll do, send it, Alex, do you know? Can you run it?
I don't
please?
have a vehicle either.
I'll run it, Your Honor.
Then you will need to get a portable breath test device. And when you do that,
The scram monitor? Okay,
I'm paying for it now.
Okay.
That thing's around $400 to $500 a month.
okay. I understand.
So as opposed to the handheld device, which is probably about $100 a month. So if you want to keep it, you can, but it's costly. And once you get on probation, I can't pay for it for you. You will be responsible for the fines and fees. I can take off and I can reduce your fines and fees, but there's outside vendor stuff I can't pay for, like your DW education class, you'll have to pay for that. It's $30, right? The victim impact panels, you will have to pay for that. TRAS, can I waive the fee? I'll waive your TRAS fee, which is around, that's what, $200? Yeah, so I'll waive that fee for you. But remember, this probation is not about the money. It's about you doing what you're saying you're going to do in the time that they tell you to do it. So there's a certain time for you to finish everything.
It's suspended.
Your license is not suspended. So one of the other things I wanted to.
No, it is.
He was suspended.
There's an ALR suspension.
There is a
isn't
suspension.
Yeah, it is.
Yes, sir.
So we will, as part of this probation now, require you to get your Texas driver license. I want you to get it so that at some point you can become a legal driver, but you have to have insurance and you're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught, then that's a violation of your probation. Don't just do stuff. You get permission first.
Yes, sir.
Don't try to do and beg for forgiveness after the fact because it doesn't work here.
Yes, sir.
You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigrants will now reflect as a conviction on your record. From now on, you'll be facing a minimum of 30 days in jail. No proverbial slaps on the wrist. You understand?
Yes, sir.
Do you have any questions?
So what, does that mean I can go, when do I go take the scram monitor?
First, you get the portable device. When you get that, we will take that ankle monitor off. I want to know that you have something that's testing you before we just take that off. We're not going to take your word for it that you're going to get it, you know?
Yes, sir.
But the minute you get it, let us know and then we'll take that off and then you can keep the other one. If you fail, if you pick up a new case, don't do your stuff. I will issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out in Orange and we're going to talk about if you violated or not. And if they prove it to me, you're looking at 180 days in jail.
Yes, sir.
You understand? You have any questions? How do you plead to the offense? How do you plead to the offense? Guilty or not guilty? All right. I will find you guilty. I'm not going to suspend your license. So just take care. You have the ability to get it back. You know, that's what you do, right?
And it's
Until you-
also,
there's nothing wrong with it.
also work from home as well, so.
Great. Just take care, you know, work at home, stay at home, make a lot of money, keep a lot of money in the bank, and then you venture out. Don't do things backwards, like have a kid now, because that's, do you have any kids?
38 years without kids on.
Well, perhaps one day you'll get blessed, but just do things in the right order, and then things will work out for you. I'm going to waive your supervisory fees, your DPS fines and fees and surcharges. Meaning I'm taking off around $4,000 of fines and fees that you would otherwise be required to pay. And if you don't get a license. But I'm going to tell you now, if you come back here with another DWI, a second DWI, there's a surcharge of $6,000, not to mention court costs. So you roundabout leave here with about $7,000 in fines and fees. So if you want to get lit in the future, just don't get into a car.
I don't have any interest in drinking at all anymore, honestly.
Time heals all wounds, Mr. Houlihan. Say it again.
Talk to him about marijuana too. Because that seems to be the problem.
Marijuana can be, it can be a DWI with marijuana as well. It doesn't have to be just, if you take too much NyQuil, what happens? Right. So it doesn't have to be just alcohol. All right. Good luck. Don't smoke weed. Smoke weed. Mr. Cope. How are you?
Amazing.
I'm sorry?
Amazing, sir.
I hope. I really hope. You know, you've got a lot of stuff going on. And
What makes this courtroom session so intense is how quickly second chances can disappear once the court believes someone isn't learning from their mistakes. Some defendants walked away with another opportunity, while others faced harsher consequences because the judge believed public safety had to come first. Cases like these show how fast one bad decision can snowball into life-changing consequences. Who do you think deserved another chance here? If this courtroom breakdown shocked you too, drop your thoughts below and subscribe for more real courtroom drama and legal analysis.